Stephen Gold. Did you say you couldn't find a decent present to give for Christmas? Dare I? To evict or not to evict?
That is the question.
That'll do, Mrs. Shakespeare. The dilemma arises because on the 1st of May 2026, the Renters' Rights Act is to be brought into force in England. This introduces the biggest shake-up of the law on letting out homes for years. The major reform concerns the abolition of no-fault evictions for private as opposed to social housing tenancies. This is the process by which landlords have been able to let their properties under so-called assured short-hold tenancies and get the tenants out through a court order obtained at the end of any fixed period. Just 2 months' notice to a tenant, often described as a Section 21 notice, that the landlord wanted them out is all that's been needed. And no reason for wanting them out. The tenant could have behaved impeccably in paying rent on the dot and keeping the property so clean that the landlord could have been invited round and eaten a meal off their kitchen floor. Provided the necessary procedures were followed, the court has had no option but to grant possession to the landlord, and usually on the written paperwork submitted, and so without a court hearing. The new Act means that assured short-hold tenancies are abolished, and eviction of a blameless tenant will generally be at an end.
But what about the existing tenants?
Well, they too will benefit from the reforms from May onwards, so long as their landlord hasn't taken repossession steps beforehand.
So where's the dilemma for landlords?
Well, before the 1st of May 2026, landlords can take advantage of the existing law and move to have an assured short-hold tenant evicted under a current regime, give at least 2 months' notice to a weekly or monthly tenant that they want them to go without any reason, and apply to a county court for a possession order, even if it is after the 1st of May that they do so. But then there'd be a time limit for taking that step of 3 months. They have up to the 31st of July 2026.
So they serve a Section 21 notice before the 1st of May?
You've got it.
And how do they decide whether or not to take that action?
Well, a major factor in their decision will be what they reckon of the grounds for eviction that will exist from May onwards. Here's a taster. Rent arrears. Here, the court will be obliged to order possession, but the level of arrears needed for it to do so will be higher than currently. 13 weeks rental unpaid will be required instead of the current 8 weeks, or if rent's payable monthly, 3 months arrears instead of the current 2 months. The landlord, though, will be unable to start court proceedings until they've given 4 weeks' notice at least to the tenant of their intention to do that. It's currently 2 weeks, which means that the landlord could be without any rent for around 4 months before they can even start possession proceedings on this mandatory ground. Canny landlord might not wait that long and attempt to oust a determined non-payer on discretionary grounds of possession that already exist. They are simply that there are some arrears or that the tenant is a persistent non-payer. There the court is not obliged to order the tenant out, but could well do so if not a penny's been paid, or at least make a suspended order of possession. You can only stay if you pay the arrears in a fixed way and future rent as and when it is due. Incidentally, if the tenant is on universal credit, which includes an element for rent, and that element hasn't yet been paid over to the tenant, then it will be ignored for the purpose of calculating the amount of the arrears. What I think we'll see is closer scrutiny of the financial circumstances of prospective tenants, and references, particularly from previous landlords, and landlords calling for guarantors for rent payments. However, it would be unlawful to discriminate against a prospective tenant on the ground that they are or may be claiming benefits.
What about requiring the tenant to pay a hefty amount of rent in advance?
1 month's rent in advance, that is all that will be allowed.
Say the landlord wants to sell up.
Well, of course, they can sell up with the tenant in possession, so long as they can find someone to buy. If they want to sell with vacant possession, that's catered for by a new mandatory ground for possession, which can only be exercised after a tenant has been in for 1 year or more, and the landlord has given at least 4 months prior notice to the tenant. It will matter not that the sole reason for selling up is to get rid of a tenant, and a more flexible ground for possession is introduced where the landlord wants to move into the property and use it as their only or principal home. In fact, not necessarily for the landlord's occupation. It will be sufficient if the occupation as the only or principal home is to be by the landlord's spouse, civil partner, cohabitee, or other close family members such as parent, grandparents, sibling, child or grandchild, almost an Uncle Tom Cobley situation. Again, though, not for the first year of a tenancy and at least 4 months' notice to the tenant required.
Is there a risk that the landlord might put the rent up to a figure beyond the reach of the tenant?
No. Rent increases will be limited to 1 a year with at least 2 months prior notice to the tenant and to the market rental only. The tenant will be able to take any dispute on what is the market rental to a tribunal.
So who are the winners?
Well, undoubtedly tenants. After all, the Act is called the Renters' Rights Act, and it's fair to say that they needed greater protection against unscrupulous landlords. But there's a strong case for saying that the Act goes too far in favour of tenants, and the risk is that accommodation in the private sector will become scarcer. We shall see. Before making an employment tribunal claim, you're generally required to contact ACAS about the dispute, and they will do their bit to bring about a settlement with your employer, past or present. ACAS then has a 6-week period to work wonders. But because demand for this conciliation and the complexity of disputes has risen so steeply in the last year, ACAS conciliators have been under too much pressure. In some instances, they've even had to forego any pickle with their lunchtime cheese sandwiches. So what's happening? Well, the 6-week conciliation period is being doubled to 12 weeks for referrals to ACAS from the 1st of December 2025, this month.
Where's my money?
You mean the payout of between £45 and £70, which you can expect to receive at some point for doing little or nothing?
That's a bit harsh, Stephen, but I suppose you're right.
This is all about the class action brought in the Competition Appeal Tribunal by Walter Merricks, you probably never even met him in the street, on behalf of millions of people who between May 1992 and June 2008 paid for something from a business that accepted Mastercard, even though they didn't necessarily use their Mastercard on any transaction during that period. More of the background's on my blog, details in the fact sheet. Most of the cardholders unlikely to have had a clue that this claim was being made. Anyway, the claim was settled, and the settlement approved by the tribunal earlier this year, with Mastercard agreeing to stump up a cool £200 million to be shared among cardholders, including probably you.
So, where's my money?
Steady on. The tribunal claim was financially backed by litigation funders. The higher the settlement, the higher their cut for backing the claim. The funders challenged the settlement, saying it was too low. The challenge failed, and the funders have just been ordered to pay the legal costs of Walter Merricks and Mastercard for making that challenge.
Good. So where's my money?
Last June, the funders went to the High Court for permission to apply for a judicial review, a different challenge this time, of the tribunal's directions on how the £200 million is to be distributed and the amount of their cut.
Not so good. So where's my money?
Well, because of this latest challenge, the distribution's been stayed, halted, and we must await the outcome of the High Court case next year.
When will that be?
Can't say. But if you're short of a penny or two, how about a cashback withdrawal on your Mastercard? Fees charged by Companies House are changing on the 1st of February next year. Most are going up, surprise, surprise. A few are going down. So, for example, if you incorporate a company online before then, you'll save £50 for fees being doubled. And by putting in an online confirmation statement prior to February, there'd be a saving of £16. Over at the Intellectual Property Office, fees are set to rise on the 1st of April next year. If you want to register a logo for your brilliant cherry stone picking device invention, do it before then and save £35. The new fee will be £170 for a trademark application, and save £50 by making an early patent search, where the fee is up from £150 to £200. The fee for registering a lasting power of attorney went up by a tenner on the 17th of November. And for getting hold of copies of probate grants and, where there was no will, letters of administration grants, there's been a whopping rise from £1.50 to £16 a copy. And that will also apply when you ask for additional copies when applying for probate or administration grants to send out to banks, building societies and others while winding up an estate.
The increases have already come in. What sort of saving is that?
Well, a very lousy saving, I'm afraid. I hang my wig in shame. Perhaps you'll let me off as I can offer that anyone who benefits on a low income can use the help with fees scheme to have the power of attorney or probate fees waived or reduced. And where on benefits, they've just scrapped the need to produce written evidence that benefits are being paid. This relaxation extends to help with all court fees as well. 2-year-old Awaab Isaac died from a respiratory condition due to prolonged exposure to mould in his home. His family had told their social landlord about the mould even before Awaab was born. The landlord did nothing. The family campaigned for Awaab's law, and they got it in England, and it became effective on the 27th of October 2025. Now, that law requires social landlords to ensure they pull their fingers out over significant hazards which are their responsibility and relate to damp, mould and fungal growth or most other emergencies. More hazards will be added next year. This is really a big deal for affected social tenants. The clock will start ticking for the landlord on the first working day after they're notified of the hazard. It must make an initial decision about whether the hazard is significant or an emergency. If significant, it's to investigate within 10 working days. If an emergency is suspected, it's got to decide what to do within 24 hours. And any further investigations, such as a survey, are to be carried out as soon as reasonably practical, and any necessary safety work dealt with in the meantime. There are other strict time limits for repairs and suitable alternative accommodation for the tenant where required while the repairs are carried out.
What happens if the landlord ignores the tenant's complaint? 100 lines?
Much worse than that. If the landlord fails to act as the new law commands, the tenant may sue them in the county court to compel them to act and for compensation. The defence available to the landlord is that it made reasonable endeavours to avoid breaking the law. This law doesn't apply to private lettings yet. It will under the Renters' Rights Act, which arrived on the statute book in October. The government is yet to announce when the extension of Awaab's law to the private sector will be actioned, along with the introduction of a decent home standard to the private sector. It will be consulting on these matters, yawn, yawn. Watch this space and this face. Sorry about the face.
The free Law Watch fact sheet that Stephen mentioned is available from www.breakinglaw.co.uk. Stephen Gold is the author of The Return of Breaking Law.